Your Honor, just one last point. This all began with this idea, argued very thoroughly by the Attorney General, that all this financial crime stuff is to prove that on the night of June 7th, he knew, because of that conversation in the office, that the jig was up, that he, in a day or two, that hearing on Thursday, everyone would know that he was a thief and everything had crashed down on him. And to distract from that and delay things, he went home and butchered his son and butchered his wife. And by the way, I might point out, that same day he learned his father was terminal and wouldn't live much longer. And that would be, in my opinion, as much of, if not more, well, enough of a distraction.
I agree.
For, you agree? That that he didn't need, I mean, there's no rational way he would think he'd need to butcher his wife and son to distract, knowing his father's getting ready to die, which would be a distraction in that community, in that law firm. So again, I think we need to get back to why we began this 3 or 4 or 5, I can't remember how many days we've been doing financial. I mean, this is a murder trial, not a financial fraud trial. And to the extent it goes to motive, again, we're more than willing to stipulate that this amount of money disappeared, that the rightful heirs of it, receipt of it, didn't get it. But putting a child on the stand to talk about, and again, he didn't know when he found out about it, or when he began to raise those issues.
I believe he's an adult, isn't he?
He is an adult. He has a job in an emergency room as a tech.
I apologize to the young man. He looks young to me. I'm sorry.
Anything further?
Your Honor, the only thing I would say is that the state's theory isn't as simple as that. It's broader than that. But again, I think that this is a different category, and it's part and parcel of everything that was going on as we moved to June 7th, and therefore is relevant for the jury to understand very much as the pressures that could cause him to murder his wife and son, particularly in the face of the defense contention that he could never do such a thing.
Satterfield testified in camera that in June of 2021 he made a call to Mr. Murdaugh asking about the status of the case. He made that call, he testified to, because he had heard reports that that there was some concern about the status of the case sufficient to cause him to call Mr. Murdaugh to ask about the status of it. And he testified that he could not remember if he called Mr. Murdaugh or if Mr. Murdaugh called him. But yes, I talked to him in June of 2021. That's according to the rough draft of the transcript that has been provided to the court. I find that this testimony is consistent with the state's theory of of the defendant being in a frantic state, seeking to avoid disclosure of these financial crimes and thefts, and that this testimony is consistent with the state's theory. The court has granted the state's motion to allow evidence of other crimes, and this is additional evidence that that is close in point in time and is admissible, and I deny the motion to exclude it. Yes, sir.
Bring to your attention one factual issue. The Attorney General has...
Of course, I asked, is there anything else? But go ahead.
I apologize, Your Honor. I'm trying to hurry if I can, because there may be an ending to this case someday, but I'm not trying to delay it. The phone records the Attorney General is going to present through this witness indicate the only calls between the two of them were on June 22nd, 2 weeks after the murder. So if there's some phone call, there's no mystery about when the phone call came. After June 7th, 2 weeks later. So in terms of him putting Mr. Murdaugh on alert that something imminent was going to happen, it's 2 weeks later.
Well, it's impossible for anyone to know what's on one's mind or state of mind at any given point in time. But the magnitude of this case almost morphs all the others in the amount, and it is something that I would, if one is being concerned and attempting to prevent disclosure and seeking to divert attention from the impending disclosure of information, and that disclosure would likely have taken place not only for some of the others that we've had testimony concerning, but most definitely this particular one. So I understand your objection. That's a fact and issue, but I find that it's more probative than prejudicial for all of the reasons I previously explained. Yes, sir.